Welcome to this Bristows webinar entitled GDPR First Anniversary, Are We Proactive to Improve? My name's Robert Bond and I'm a partner in the data protection team here at Bristows in our London office. And we're joined today by Winnie Chang from her law firm in Singapore, and also Norris and Richard from Ankura. And they're sitting round the table with me, and I am going to ask Winnie just to quickly introduce herself.
Hi everyone, this is Winnie. I'm the Managing Director of OrionW, which is a Singapore-based law firm specializing in technology, media, telecoms, and fintech matters. And I'm very privileged and honored to be invited to join this webinar. And thank you, Robert and Norris.
Thanks, Winnie. Thanks, Robert. Hello, everyone. I'm Norris. I'm the Managing Director, Data Privacy of Ankura. I'm leading the UK, EMEA, and APAC data privacy practice.
Hi, everybody. I'm Managing Director at Ankura of the Cyber Incident Response Team at Richard Patterson. And as my title would suggest, my work involves helping clients and assisting them during cyber breaches and data breaches, and it's a pleasure to be speaking to you today.
Thank you. And just admin, if you have any questions, please use the question box as we go along, and I'll either take the questions if they're immediately relevant, or otherwise we will deal with them at the end of the webinar. The webinar is going to be recorded, or is being recorded, and the recording will be available from the Bristows website later this week, if not early next week. So what are we going to cover today? I'm going to look at some of the legislative developments to date. Winnie and I are going to look at some of the emerging trends in other parts of the world and how that might assist global companies to have a more, if possible, one-size-fits-all approach. And then Norris and Richard are going to look at global privacy and security improvement programs and continued operations and improvement around privacy, cyber, and eDiscovery. But before we go further, we've got 5 polling questions for you, which we'd love to have you answer. So if we can take these one after the other. Our first one is, what is your top GDPR activity that needs improvement? And we've given some suggestions, so be interesting to see what your answers are to those. And I'm seeing the responses coming through as I'm talking, and it's a fairly, almost I was going to say, evenly distributed mix. Okay, so what we've ended up with is about 31% looking at the Article 30 record of processing, 23 data protection impact assessments, 14% only addressing data subject access requests, 20% data incident response planning, and 37% training and awareness. Good. Okay, let's go to our next polling question, please. Are you confident with your GDPR maturity journey? I'm keen to see who is the I am 100% confident here. Maybe there is somebody out there. And we started with quite a lot of people saying yes, but it seems to have split itself up here. And we're looking at about 31% or 33% yes, 30% no, and 38% not sure, or hedging their bets, as I might put it. Okay, thank you. So polling question number 3. Do you plan to improve your GDPR program in the next 6 months? And as you know, you've got 3 options there, which is a straight yes, or it's no due to budget constraints, and not sure. Okay, so 73% of you are saying yes, we do plan, 5% saying no due to budget constraints, and 23% saying not sure. Okay, nearly getting towards the end of the polling questions. How do you operationalize the General Data Protection Regulation? And we've given you 3 options: manual by documents, fully automated through internal systems, or semi-automated using a third-party or third-party tools. And again, I suspect we will see a mix here. Okay, and interestingly, about 41% say manually by documents, only 11% fully automated through an internal system. And I guess just at the moment, it's not surprising that 49% are semi-automated, but using third-party tools. Okay, and finally, and thank you, by the way, for answering these, do you think that data protection authorities across the European Economic Area have provided clear guidance on compliance with the GDPR? Not a lot of yeses as people are completing this, which doesn't surprise us. Okay, and so only 4% of you say yes, clear guidance. 35% say yes, but it should be more practical, and 61% say no. Okay, thank you for answering those. That actually informs us as we go forward, so we appreciate that. Okay, so when we look post 25th of May 2018, I decided to put together what are all the policies and procedures that we've ended up with. And interestingly, and this is not a test question, but I have left off there the Article 30 record of data processing. I realized that after I'd completed things, but there are so many things that you need to have in place, from the overarching code of practice to how do we deal with recruits, how do we deal with employee data, how do we deal with customer data, what's our privacy statement look like, our cookie statement, and then we get into the how do we deal with privacy by design, how do we deal with data protection impact assessments, how do we deal with incident responses, how are we dealing with data subjects. And I think we're all learning that actually rights of erasure, rights of portability are not absolute rights, and we have to remember they dovetail with other legal requirements. And then we're starting to think about bring your own devices and managing the use of social media in the workplace, and it honestly goes on. And I'm sure that any of you looking at this slide will say, he's forgotten this, we also have that. And the difficulty is it's enormous. And when you look back at this from a business point of view, implementing GDPR was the start. For a lot of organizations who were already compliant, it shouldn't have been a huge challenge. Yes, we had to be more accountable. Yes, we had to be more transparent, but a lot of the building blocks were already in place, though my experience was that an awful lot of businesses were not compliant. And then we had all of the items that we hadn't had to think of before, like the increased fines, like more mandatory data protection impact assessments. But interestingly, I think a lot of the data protection and compliance officers I've spoken with have said that we've suddenly realized that legacy systems can't be changed overnight. And although it's not all about IT, we do need IT to be involved in helping us to really understand the who, what, when, where, why, and how of all of that information that we have. And when you look at the challenges, and probably data governance is the ultimate prize, IBM talk about the data dictionary, understanding the entire data estate that you have, and then developing quality data. And we do know that there is still data that is actually toxic. It is so inappropriate and unqualified that it's actually worse to keep it than to get rid of it. And I'm sure that there is still a lot of focus on, do we really need that? How do we manage decisions? Who are the core team that are going to address the data incident? Do we have a single customer view if we're very consumer focused? Do we genuinely know across not just our IT system, but our devices, our instant messengers, our WhatsApps? Do we really know where all the data is when an individual aggressively says, I want you to do X, Y, and Z? It's becoming harder to actually respond effectively to some of these requests. How do we deal with these issues and escalate them? Data retention. When we looked at this, it was keep data no longer than is necessary. And then you actually find in practice that it is not as simple as saying we keep it no longer than is necessary. We need to remember that retention of personal data bumps up against other laws that require us to keep data for much longer than an individual might require. And we need to be aware that when things go wrong, the regulator will need us to robustly talk to them about the methodology that we apply to retention periods, for example. And finally, we need to get the executive buy-in. And I still get asked, how do we get the board to take this seriously? And I put my hands up and say, cause a data breach. It usually does cause resources to be found. That's a bit of an extreme measure, but a lot of businesses, I've certainly found organizations outside the EU caught by GDPR saying, but nobody will come and get us. I think we will see a lot more enforcement. So moving to the next slide, I just thought I might mention the dreaded Brexit, the deal or no deal. I don't have a crystal ball, but my best bet is that when we leave, if we have a hard Brexit, we won't be deemed an adequate country to receive personal data. We won't have got a negotiated arrangement. We might rely on consent and other mechanisms to receive data. But if you're a multinational with offices in France and Spain and Greece and Sweden, they will not be able to transfer the data unless you've already got a contractual mechanism in place, whether it might be binding corporate rules, whether it might be excuse me, standard contractual clauses. The trouble is, this is not tried and tested, but we are going to have to think about what happens if we have a hard Brexit, because data will not stop of its own accord. It will still be moving, and so 1 second you'll be lawful and 1 second you'll be unlawful. And I've put the initials ODTA there in the box because we tend to be working with an omnibus data transfer solution, a framework agreement using the model clauses that doesn't stipulate the UK is an exporter in the EU. We simply say where any member of the group is in the EU and is an exporter, and that seems to be able to straddle the divide of a hard Brexit. But just as importantly, for businesses to think about in terms of post-GDPR is if we are not in the EU, then the UK regulator, the Information Commissioner, is not at the table. We aren't going to be there with the Article 29 working party. If you happen to be a US organization or even a Singapore organization whose only other operation is in the UK, if you are still selling goods and services into the EU, you're subject to GDPR, but you don't have another entity. So you're going to have to appoint a representative in the EU member state where you have the most connection. Where's that going to be? How are you going to do it? Who's going to be the representative? And if you had to have a mandatory DPO, where do you put the DPO? And you're probably going to end up now with not a one-stop shop. You're going to end up with an ICO not in the EU, and then at least one other regulator in the EU that you've got to interact with. So who is your lead supervisory authority? is another challenge. And finally, before I hand over to Winnie, when we start looking at the wider world and the increase in the number of laws coming through, whether it's the California Consumer Protection Act or the new law in Bahrain or the law in Kenya or the new law in Brazil, my general rule of thumb is if as a compliance officer you want to understand how data protection would be viewed in another jurisdiction, think about colonization, think about Commonwealth, think about conquest. It is not surprising that Argentina looks like Spain, that Uruguay looks like Spain, that Brazil looks like Portugal, that Vietnam looks like France, that South Africa, Singapore, Malaysia, very British influenced. It's not a perfect choice, but it's certainly one that would help you to see how your issue might be addressed by a regulator in some other part of the world that you've not necessarily dealt with before, but now you have a breach incident of their citizens' data. Talking about other parts of the world, I want to hand over now to Winnie to take us through what's happening in the APAC region.
Yes. So as you may know, quite a number of APAC countries have already passed data protection laws in the last 20 years. So for the purpose of our discussion today, we're going to focus on just 6 of the examples listed on the slide. So we don't have time to go through the details, but we're just going to focus on 1 or 2 issues. The first one, it's about extraterritorial application. We all have heard about the impact of GDPR on global businesses, as Robert mentioned earlier. So the impact on global businesses, that would include impact on APAC businesses selling goods and services online to data subjects in EU. So the question is, do the APAC data protection laws also have extraterritorial application? So the answer is, some of them do. So for example, the laws in Australia, Singapore, and South Korea, as shown on the slide, do apply to foreign companies that collect or process personal data in Australia or Singapore respectively, and also in respect of Korean citizens. And the data protection laws of Japan and Malaysia also have limited extraterritorial applications. So for example, in Japan, certain key provisions of the Japanese law do apply when foreign companies receive personal information when providing goods or services to a person in Japan. Whereas in Malaysia, for example, the local PDPA, the data protection law, applies to entities that are not established in Malaysia, but use equipment in Malaysia for processing personal data. So it's really important for us to be generally aware of the extraterritorial applications of these APAC data protection laws to ensure compliance in this area. The other point I just wanted to briefly mention is about data protection officer requirement. So out of the 6 countries, Malaysia does not currently require companies to appoint a DPO. But in Australia, Hong Kong, and Japan, there's also no such DPO requirement, but it is recommended in these 3 countries that it is a good practice to appoint one. Whereas in Singapore and South Korea, it is in fact mandatory requirement to appoint a DPO. And if there are questions later about DPO, we can address that a little later. So there are some common themes among the APAC data protection laws. And before we talk about that, I want to mention that consent, for example, not all of the APAC data protection laws referred to earlier require consent as a basis for collecting and processing personal data, although most of them do. So for example, Malaysia, Singapore, and South Korea do require consent, unless it's an exception that's permitted by law. Whereas in Australia, you will be allowed to collect, for purposes which are reasonably necessary for the data controller's business functions or activities. When it comes to similarities, there are quite a number of them, especially in relation to the requirements for notice, purpose limitation, accuracy, protection, and retention of personal data. So, for example, you can only collect PD, personal data, after giving proper notice to data subjects regarding how the data, will be used and disclosed. And as all we can, as all we know, data cannot be used for purposes other than those which were notified to data subjects at the time of their collection or for which consent was obtained. And in all of the 6 countries, we're discussing now, data controllers or users are required to ensure that personal data in their possessions are protected, retained only as necessary. I mean, that's obviously sometimes can be quite difficult to ascertain, and they ought to be kept accurate and up to date as well. And the other point that's part of the common principles is that individuals in these countries are generally granted access and correction rights. Currently, all of the 6 countries do not grant data portability rights or the right to be forgotten, except that South Korea does grant individuals right to request the deletions of their personal data. And the last point about direct marketing rules, in the APAC jurisdictions that we're looking at, the laws, data protection laws that do require consent to use personal data for marketing purposes. So that's quite an important point. So consent remains one of the core principles. Although there are additional or special rules that apply depending on the medium used for marketing. For example, Australia and Singapore, the 2 countries do apply special rules for commercial electronic messages under the respective Spam Control Act. And in Australia, Hong Kong, and Singapore, for example, they do have do not call registers that will be applicable depending on the medium used for marketing. So lawmakers in the APAC region have been very busy analyzing the GDPR, with a view to updating their own national data protection regime. So over in Singapore, that's where we are based. So Singapore government is also considering amending the PDPR to be more in line with PDPA to be more in line with the GDPR. So we are going to take a very quick look at some of the key proposed amendments. So number 1, Singapore proposed to expand the legal grounds for processing personal data. Currently, the PDPA, the Personal Data Protection Act in Singapore, adopts the consent approach. So it only allows collection and processing of personal data with express or deemed consent of an individual, unless, of course, an exception applies. However, the regulator is considering adding 3 additional grounds. So 2 of them you'd be quite familiar with. One would be notification of purpose or deemed consent by notification approach. And under this approach, you can process the individual's data once you have notified them of the purpose for processing their personal data. And if they do not opt out of such processing within a reasonable time, then you can proceed to process such data. However, you can only rely on this ground if the data processing is not expected to have any adverse impact on the individual. And companies are encouraged and will need to conduct a risk and impact assessment to determine whether the intended processing is likely to have any adverse impact on individuals. And the second additional ground that's been proposed is the legitimate interest approach. And under this approach, you can process personal data if you have legitimate interest to process personal data without consent, provided that the benefits to the public clearly outweigh any adverse impact or risk to the individuals. And examples of such legitimate interests would be the prevention of fraud. And again, organizations will be required to conduct a risk and impact assessment to determine whether the benefits outweigh any foreseeable adverse impact to the individuals. And Norris will talk about the program a little later. And the third additional ground, and that's an interesting one that has just been proposed recently, and in through the consultation process, and the consultation is actually still ongoing. So the additional ground is called business innovation purposes ground. So it means that as an organization, you may use data to derive business insights and innovate in the development and delivery of your products and services without notice or consent. However, you do need to give notice and obtain consent in order to collect and disclose data for business innovation purposes, unless another exceptions to the consent requirement applies. So this is the latest kind of new ground that has been proposed in Singapore. It's also important to note that none of these new proposed grounds above that we just discussed may be relied upon for direct marketing purposes. And the second point is the mandatory data breach notification. So currently in Singapore, there is no requirement in the PDPA that organization must give notice of data breaches, whether to the regulator in Singapore PDPC or to affected individuals. However, that is going to change because the PDPC has already proposed to make it mandatory the notifications of data breaches, which are likely to result in significant harm or impact to the individuals to whom the information relates, or are of a very significant scale. And the example that has been given so far, what is a significant scale? So that's you're looking at a breach that would involve personal data of 500 individuals, for example, that would be considered fairly significant scale. And that's in line with the guidance that has been issued by the regulator in the country on managing data breaches. So the law will be passed to introduce this mandatory data breach notification requirement in Singapore. And finally, it's the data portability obligation. Currently, the PDPA in Singapore does not grant individuals a data portability right. However, the PDPC has just proposed amendments to the PDPA to impose the data portability obligations in respect of personal data in electronic form. So under this proposal, a company or organization must, at an individual's request, provide that individual's data in the organization's possession or control to be transmitted in a commonly used machine-readable format to another organization that has presence in Singapore. So the porting organization may be allowed to impose a reasonable fee for this service. And what does this obligation apply to? And this is an important point, and it's still being discussed and consulted currently, so it's not quite set in stone. This data portability obligations will apply to data that are either A, provided by the individual to the organization, or B, generated by the individual's activities in using the organization's products or services. So user-generated activities, that could be clicking likes, on Facebook. That's kind of one of the examples. Whereas they have made a distinction of derived data to make sure that derived data will be excluded from the proposed data portability obligation. And what is derived data? That's new data element created through the processing of other data by applying some sort of business-specific logic or rules. So that would be derived data. But currently, this concept is still being debated and has not been passed, implemented in Singapore yet. And the proposed amendment is going through public consultation, as I mentioned earlier, and that will carry on until 3rd of July. All right.
Thank you. And certainly from the lawyer's perspective, and going to hear from Ankura in a minute, what we're finding with multinationals who may be US headquartered but operating not just in the EU and other parts of the world, that if you have invested significantly in trying to be GDPR compliant and you've got your policies and procedures and training programs in place, this is a bit simplified, but you could view using all of that investment in the GDPR to say, okay, so we've got GDPR, but then we've got GDPR style countries, and Singapore being one and others that Winnie mentioned. We could see how we can shoehorn those policies into, maybe with some localization, but not starting from scratch. The US, despite the Consumer Protection Act in California and despite draft legislation in Washington state, it's still sectoral. It is a different approach than what we're used to here. And then you've got the rest of the world where there might be no law at all, or there might be something that's quite unique. And I know this looks simplified, but it is actually quite a useful approach to take when you are saying, what's the return on the investment when we try to utilize all this in a larger global approach. So I do have a question which I will leave to the end for the person that sent that in, but for time purposes, I'm going to hand over to Norris and then Richard.
Thanks very much, Robert. A while ago, Robert has excellently and beautifully mentioned about the current landscape on GDPR and Winnie on the APAC side. So what we're covering is very much on the improvement program and the implementation aspect, what we have seen in the market and what we've been observing in the market for the past 6 months. So I'll be covering 4 areas. The first is on a case study in relation to an M&A. Second, a case study in relation to ag technology. And the third is a case study in relation to governance. And the fourth point I'll be talking about at a very high level in relation to the impact of GDPR vis-a-vis eDiscovery. So if you look at page 16, which is a case study 1, the turnaround and restructuring. So the context is that the global HQ is in California, EMEA HQ is in London/Dublin, and APAC HQ is in Singapore and KL. So the M&A took place a week after 25th May. You just imagine, like, this company was so busy, and suddenly the acquisition actually took place a week after that. So there were 2 scenarios. The first scenario is at a point of time when they did the GDPR assessment, they actually realized that the governance structure was very much centralized. But after the post-acquisition, some of the business activities are channeled to certain business processing with regards to marketing, HR, procurement, and as well as the third-party vendors. So the huge challenge when it comes to this kind of scenario is how we would like to actually really develop a global privacy framework. A global CPO might say, well, we just do GDPR, or maybe some of the legal counsel might say that, well, we can just use our local laws approach. Some regional legal counsel might say that, no, we should use actually APAC approach. So we've seen a lot of this kind of conversation in the marketplace. So in essence, what exactly this case study has actually highlighted is that GDPR is not just about the compliance aspect. It's also about understanding the privacy and security culture of the organizational environment. And this is actually where we think that it's very important and equally important for stakeholders to A, connect with the wider stakeholders, and B, to be able to tell to the wider stakeholders, hey guys, it's actually a journey. Okay, 25th May is just the end of the beginning. We have a lot of work to do. And in the context of the M&A, what we also realize is that there's no one-size-fits-all kind of global framework. But thanks to GDPR, a lot of organizations, especially multinational, would like to view that can we develop a global framework with GDPR in mind? And that links back to Robert's important point, whether or not organization would like to have an EU style or perhaps the APAC style or a GDPR kind of embedded model. So that's actually the first case study. So let us look into the case study 2, which is the technology. As you guys on the call are aware that there are lots of social media platforms nowadays, I should not mention the name, but it's so complex business model. Consent is not just the solution in this platform, because in terms of the complexity of the way they share the data, they also share data with a third party, with sub-processor, with even many sub-processor, not just within the EU, but also outside the EU. So this leads to 3 angles. The first angle is it high risk in an edtech space, or is it a mitigable risk? And then second, because of the fact that it's so complex, a lot of organizations assume, oh, okay, we have this GDPR, when we do the PIA, that will actually solve the problem. And that itself is not actually the way to approach it, because you need to actually engage with the data protection authorities, not only within the EU member states, but also outside the member states. And this is actually where we have seen a lot of confusion. In the edtech space, one of the things that we learned in this space is that you need to actually continue validate the data flow. As what Robert has mentioned a while ago, Article 30, the data flow, the data inventory, the data mapping. And second, not only validate that, engage with the relevant marketing people, data governance people, data scientist people, and the third-party vendors within the edtech space, is it how they actually really process the personal data. And what we learned so far, this is actually an emerging risk. Even after 25th May 2018, there'll be a lot of conversation, interaction, and consultation between regulators and as well as key stakeholders in this particular domain. So let us go to case study 3, page 18. A while ago, Robert highlighted about the percentage of the so-called poll, and interestingly, that actually resonate based on the experience that we have actually undergone so far. Winnie also mentioned about the role of DPO, and if you look at this slide, we've seen a lot of organizations still struggling. Where do they want to put their DPO, the reporting of the DPO, the governance model? In the US, typically the term is Global Chief Privacy Officer. That typically covers partly privacy and partly security. In EU, mostly data matters, work closely with the General Counsel, compliance team, with the Privacy Council. In APAC, it's very different because of the appetite of the particular sector, where we've seen a lot of DPO are starting to actually go beyond the typical compliance activities. And we have also seen the emergence role of Chief Data Officer, CDO. Interestingly, when I was in the Global IPP Summit in Washington, DC, I was on the panel with one of the panelists in which she used to be a global CPO, and now she's a CDO, where from the compliance role, she's now like a role where people like to talk to her, to be friendly with her, because she's helping the organization to commoditize the data. How exactly the existing data could be commoditized in the context of the global organization business mission, business model, and business strategy. And in addition to that, if you look at the slide, there's also Article 27 rep, is what Robert mentioned a while ago. So there's a level of interplay between these actors. When I say level of interplay is that you need to work together with these guys, particularly the CIO, because the CIO is the person who really understand, the systems, the application, the platform, the risks, and as well as all of the activities that the organizations are actually processing the data within the current infrastructure and technology. And the challenge to integrate these actors is about the culture and also the people. And that's where you need to have a change management program when you want to ensure that these stakeholders work together in this particular environment. Okay, so that's on the case study 3. And then let us go to the very high level emerging theme in eDiscovery. There's a lack of clarity and guidance with regards to this area, particularly in eDiscovery. For those on the call who have actually experienced eDiscovery methods, as you know, when you do eDiscovery method, it has to be localized based on certain activities, certain instruction, certain orders by the court or by the lawyers to really collect the data, whether it's on-site or off-site. And again, it depends on the structure of the data, whether it's a structured data or unstructured data. So what we're seeing in the marketplace is that a lot of organizations who are in this space, they need to start to socialize the understanding on the data processing agreement. The data processing in the eDiscovery perspective is very different as compared to the data processing definition in data protection law. So there's no confusion that you need to actually have in mind between these two. And we have seen a lot of confusion in this space, whether the data processing term in eDiscovery is also the same like data processing term in data protection law. So I always give the very simple guidance, risk-based approach guidance to stakeholders. Look back to your data processing agreement, contextualize it within eDiscovery environment, look into local requirements as well, whether or not there's a local requirements, for example, in Germany or in France or in any member states in the EU, or in fact outside the EU, maybe in the US and maybe certain parts of Asia. And importantly, it's very important for you to understand the impact of the activities from the data localization perspective. I know Winnie a while ago mentioned about the APAC development, and China, for example, they do have a data localization requirement in China. And Turkey, there's also a localization requirement in Turkey. The draft bill in India, there's a controversial section or perhaps clause that really wants to include data localization requirement. And this has been a huge trend and debate, and in fact it's going geopolitical when it comes to data localization. So you need to look into this impact as well. So on the risk-based approach or point perspective, seek guidance from the DPAs and work with your councils and ensure that you mitigate the risk. Okay, so those are actually the 4 areas and team that I've shared with all of you. And I give the next session on cyber to my colleague, Richard Patterson.
Hi, thank you, Norris. Well, I've been asked today to talk about cyber breaches, cyber attacks, and incident response with obviously a lean towards privacy and GDPR and support this discussion. So nowadays, most mass data breaches and loss of PII at some point involve some form of cyber failure. So I'm going to start with the first slide here. And there are 4 areas of focus for a breach investigation to consider in this context. But before I start, you'll see up in the top left-hand corner the word retrospective, and it's in red. And this is of critical importance because this is your start point once an incident has occurred. We're not talking about a health check with this investigation. We're not talking about an assessment of something that may or may not go wrong. This is a very focused investigation, and it's conducted with the benefit of hindsight. Something has broken, something was clearly not right, and an adverse event has occurred. So it's not a great start point for any victim or any customer or client, if you like, to be under one of these investigations. Now, there are 4 areas of focus for the investigator, ICO. It doesn't matter what country you're operating in. And the four areas are basically a look at the controls. So before this attack, this event actually happened, what controls were in place? And to come up with a view of their appropriateness and adequacy. The next stage is to review and assess the victim, the company's approach to risk. Did the company make the effort to understand the threats? And if so, what steps were taken to address those threats? And then what actions were taken to manage the exposures? And of course, what we're looking for in that area is the word adequacy and appropriate. The next phase is the actual management of the breach. So once the event has occurred, was it identified promptly? Was there a swift reaction? Was the breach reported to the ICO in a timely fashion, and was it reported accurately? What was the leak? Was the loss of information stopped? Swift action taken to prevent further loss of data? And if the customers needed to be informed, or the owners of the data that had been lost, were they informed in a timely and efficient manner? And then the final look, if you like, is once the breach had been managed and a return to normal situation, what has the victim, what has the company done to, in the way of corrective action, to make sure there is no repeat? So if we turn the slide to the next, the next slide. So there are the outcomes we're looking for, those four areas of the investigation. So the company would want the finding that its control framework was adequate, that the risk management was commensurate, the approach taken was commensurate to the threat and the risks, and that the breach management action, the incident response, was effective and swift, and that the post-breach controls would now be sufficient to prevent a repeat. Now I've circled the two areas there you'll see in amber, the controls and the risk management. Now the reason that I put those in amber is they are more difficult for an ICO to prove. They are more subjective, more time consuming. And the two areas in red are much more objective and much easier to prove. So, and my experience is that companies that get the breach management and the post-breach controls right are more likely to escape a fine. Get either of these two wrong, the two in red, and the overall finding is likely to go against the company, the victim. Regulators and ICOs have less sympathy for the management of the failures and the management of the breach and failure to take effective post-breach action. To the next slide. So going back to the controls and risk management, I'm sure everyone on the call is familiar with this slide. So companies know who the attackers are, and that they should know that these are the people and the threat to them. And then turn again, please. So on to the next slide. And we know that there are cyber threat trends. The attack trends are there, they're published, and we should know these risks. So for the regulatory investigation, the companies, i.e. the victims, require their controls of pre-attack and the associated risk management storyboard to be defendable. So questions like, given that the companies should know who the attackers are and what their trends are, was multi-factor authentication deployed? If not, why not? Was the security monitoring in place? If not, why not? Were system patched? Again, and it's the same all the way through these series of questions for addressing those controls and risk assessment were the appropriate controls in place, and what is the explanation for either their failure or their absence? Things like, were systems patched? Were penetration tests conducted? And if so, what was the outcome of those penetration tests, and what action did the company take to reduce that risk? Was there an incident response plan in place? So plausible, defendable answers are required in order to avoid those killer words in the investigations: inadequate, appropriate, or negligent. So there are 7 common mistakes that companies tend to make in addressing their risk framework and their preparedness for a cyber event. And I'm going to focus on 2 of the list. The first one is many organizations assume that they are not a target. They believe that they are either boring, low profile, they're not a natural target, they're not a defense company or a pharmaceutical company, therefore they won't be attacked. And the reality is that not all attacks, and very, very few in terms of number, percentage-wise, are targeted. So all companies can be subject to fairly sophisticated attacks. Even low-level attackers now have at their disposal advanced tools, and they are looking for weakness, not specific companies. So that is perhaps the biggest mistake of all, is to assume that the company, your company, the organization is not a risk. And then the other point I'd like to talk about is not aligning the security program with business needs. And this is becoming more and more relevant. Over recent years, there has been an approach of taking, this is my business need, now secure it. Enable my business to operate in a secure fashion. But this is a two-way street now, and there has to be some acceptance that the business must make some compromise and sensible adjustment, and adjust the business need accordingly so that it can operate in a secure environment. So how can I achieve my business needs in a secure way? So on to cyber breach insurance. A cyber attack can be devastating, and all too commonly, businesses that have suffered a major attack can be at a standstill. They have no means of communication. Their business operations in terms of dispatching goods are at a standstill. They're not receiving deliveries, and the customers are unhappy. The threat of financial penalties if PII has been lost, and not a good backdrop for dealing with an emergency. So insurance can provide the funding, cyber response, analytics, forensics, assessments, and remedial action can be very expensive. Specialist breach lawyers are hard to find. Having insurance for data breaches, cyber attack, is also good evidence that a company is prepared for such an event, that it has looked ahead, and that also helps with the investigation in terms of the planning for such events. And the other key thing to remember is that many attacks are widespread. So you may not be the only organization under attack. In the case of NotPetya, WannaCry. And the kind of resources, the expertise required to deal with these will be in very short supply. And the insurance companies are normally at the top of the pecking order with arrangements in place for access to this resource. So definitely worth considering. And finally, again, from our experience, it's clear that not all policies are equal. And it's important that companies understand their needs, their capabilities, how they're going to respond, and then to make sure that any policy they select meets their requirements. And that, I'll hand back to you, Robert. Thank you.
Thank you. And we've got 2 or 3 minutes left, and we had a question earlier on, and I apologize that I've left it to the end, but it's quite a fundamental one. The question is, in relation to the most recent guidance on the territorial scope of GDPR, it states GDPR will apply to all personal data processed in the EU, including non-EU based data subjects. Does this mean non-EU subjects can automatically enforce their data subject right regardless of where they are based? It's a good question, and actually before GDPR, it was always the case under the old directive that if you had a controller that was based in the EU, a legal entity, whether it's the UK or France or Greece or whatever, the controller's obligation is to protect the rights of personal data of citizens, full stop. And so even under the old law, when you had an incident or when an individual exercised their right, if it was being processed by an entity subject to the old law, you had rights. And nothing has dramatically changed with the new law. So to answer the question, yes, EU data subjects can enforce their rights against a organization that is in the EU and subject to GDPR. The more interesting one is if it's an entity with no physical presence in the EU, but is caught by that extraterritorial aspect of significant monitoring or offering of goods or services. Then you may find that the offshore controller will say, well, nobody can come and get me in the Cayman Islands because I am not in the EU and nobody's going to enforce it. Well, we are starting to see regulators working together. And we've already seen with some of the very high profile issues that the FTC will work with other EU regulators and vice versa and so on. So I think there's nowhere to run almost, and there's nowhere to hide. I was going to ask Richard, this is okay, before I ask my own question, how do you think stronger enforcement of the GDPR will deal with the risk of surveillance? And is that a second question? It's all the same one, is it?
Yeah.
Capitalism business models which have resulted in the influencing of general elections, for example, following. Okay, so do we think that the risk of enforcement of fines is going to actually impact on businesses that don't care about the law anyway? I think if you don't mind me, for the person who asked it, summarizing that way. What do you think, Norris?
I think if you look into the Asia perspective, fine is not actually the favorite thing in the Asian business culture. That landscape is very, very different, very hybrid. Again, it depends on the sector that the organization is actually in. On the other hand, our experience in the UK and Europe and US generally, we've seen that this fine actually affect the brand trust and reputation. It's actually something that they need to think about in order to align, their strategy moving forward.
Yeah, and Winnie, any thoughts?
Yeah, I do agree. Although even in Asia, I think increasingly the fines, there are more enforcement cases happening in Asia now. So businesses have started to pay attention to the seriousness of the data protection regulators in the region to enforce the rules. But obviously, compared to Europe, relatively speaking, it's still a fairly kind of early stage in APAC. And reputation, the impact on reputation, I think that's definitely on top of mind of CEOs and the board.
And you mentioned, Richard, reputation in line with the cyber insurance. I mean, again, do you think, is reputation the biggest reason that it should be an executive issue, C-suite issue, compliance?
Absolutely. It's well, the fine hits all levels. It's bad news at reputation. It's bad news on the bottom line, especially when we're talking about fines that can be a percentage of global revenue. For a low margin business, that can be devastating. But the reputation is a huge factor reason for fearing the fine and for taking proactive and preventative action to not getting there. And I also think the presence of the fine is a huge factor when it comes to the incident response, because not all is lost at that point. As I was saying there, if a company having been attacked can get the incident response piece right, manage the incident effectively, and then when it comes to the post-event stage, show that it's taken serious action and addressed the problem, and there's still a possibility of avoiding the fine. So the presence of a fine has a lot of positive impacts throughout the incident phase.
Okay, and we are at the end of our time, so I'm going to wrap this up in a minute, but I was also going to say, and some of you will have heard me saying this before, that I think when we've dealt with incidents and we've dealt with non-compliance in general, enforcement officers accept that you can't be 100% perfect, but doing nothing is not an option, and you've got to be somewhere in the middle there where you can show that you were trying to do the right thing, and that's not just having the policies and the procedures and not just having the insurance, but actually having the training and getting, as I said in one of my early slides, executive buy-in. So it's back to, I think you used the word, I think, Richard, culture, or maybe it was you, not, but it's trying to develop a culture within the organization just as much as you would do for bribery and corruption and anti-money laundering and other. This is there on the same level. And we are starting to see, of course, the rise of the quasi-class action in relation to incidents now in the UK, where it's not just that you'll be fighting with the regulator, you'll be fighting with data breach lawyers for you on behalf of people whose details have been exposed, etc., etc. And I think it then will become hugely not profit-making for the business just to be dealing with all of those issues rather than doing the things that they want to do. So hopefully we are being proactive to improve post-GDPR. On behalf of you, the audience, join me in thanking Winnie and Norris and Richard. Thank you to you all around the table here. As we say, this is recorded and it'll be available in a few more days for you to download. And for clients of Ankura, Norris, you'll be able to send out the link and so on to your clients. So from us here, thank you very much for being with us, and we look forward to being with you on another occasion. Bye-bye.
Thank you.
Thank you. Bye-bye.